Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Little update on Proven Industries versus Trevor McNally. Now, if you're not familiar with this lawsuit, I did some extensive coverage of the complaint, but basically Proven Industries is a lock manufacturer. They make this thing, which is a hitch lock. Now, the issue that they have with Trevor McNally is that Trevor McNally is a YouTuber and various other platforms, and what he does is he picks locks and bypasses locks and so forth. So, what happens? Well, Proven Industries makes this thing, and then they proceed to make an advertising video where they talk about how great this thing is. They say it's super resistant to all sorts of attacks, crowbars and sledgehammers and bolt cutters. Cool, so far so good. But then they post a comment on Instagram where they essentially call out Trevor McNally, and they basically say he won't try to pick this because he only goes after the easy locks. So what does he do? Well, Trevor McNally makes a video where he bypasses this thing in very little time, basically none, using a shim made out of a pop can. Now, this does not look good for Proven Industries because if you're buying a lock, you really don't want it to be able to be opened by some rando who, and the cost of entry is a pop can. So, what's the problem with this? Now, I am not an expert lock picker, but when I bought this to review the issues, I could spot the problem right away. The issue here is this thing, this little part right there. What that is that's the little piece that holds the lock together when it's locked. Now you can see it's either spring-loaded or something that just works like a spring, and it's also got sort of a triangular wedge shape. And the reason for the wedge shape is that it allows you to just kind of push it in. It's convenient, right? The problem is that if you can get a shim, like a thin piece of metal, like made out of pop can, into the housing, then you can get it around behind that little plunger and then pull it so it depresses the plunger, and then the lock slides open. Now, I will note that when I tried to do this, I'm not good at lock picking. So I was unable to manage the attack as Trevor McNally does it. What I managed to do is I managed to get the shim to tear, and it caused the lock to fail in a way that made it just fall open. So it failed open, which is good enough if your goal isn't necessarily the best video out there, but if your goal is just, I want to steal a trailer, then that gets you to theft of trailer. In looking at this video, I actually discovered another major issue I have with this lock, and probably other ones, but we'll talk about that a little bit later. Anyway, Proven Industries gets very upset. Why? Because people online start mocking them and start basically concluding that their locks are not very good. So what they decide to do is they decide to sue Trevor McNally for copyright infringement because he uses a small portion of their video in his video, as well as trade libel and defamation and various other things for basically making their lock look bad. Okay, so before we get into it, we're going to look at Mr. McNally's original video. Now, we're going to watch this in its entirety. It includes portions that are from Proven Industries. It includes portions that are from McNally. But we really have to watch it in its entirety in order to get the full proper context. But I will be pausing it at various points to offer my thoughts. So, here we go. This is the video, and now, this guy here, this guy is not like a decision maker at Proven Industries. If you know this guy, if you run into him, don't hassle him. He's just a random employee who they happen to pick in this video. So here we go.
Today I'm going to prove a lot of you haters wrong.
Now this part really, really upset Proven Industries because you can see he's sitting there, he's watching the video on his cell phone. He's got a juice box. He's kicking his legs, and they're like, this is really disrespectful. It makes people think that our locks are child's play because you are sort of acting childish in this. Clearly, this is their first experience with internet mockery, so yeah, you can judge for yourself.
Easily break off one of our Latin locks, and today we're going to debunk that.
Juicy juice.
And show you how much it can handle.
Okay, so the first thing I'm going to note here is as soon as I saw this, I was just like, wait a minute, this guy does not know how to operate a crowbar, because this is not how you use a crowbar to get into anything. And I can believe, based on the design of this thing, it's actually probably pretty crowbar resistant, but at least give it a good try. Like, at least make it look like you're trying. This is not how you try to get into this with a crowbar. And I mean, I'd tried to do a crowbar demo, but you can see this guy's got big beefy arms, and I've got like little noodle arms. Me doing a demo would not be helpful. So, yeah. That said, if you really want to impress me that your lock is, resistant to physical attacks, the way you do that, to my mind, is you drive up to like a homeless camp where there's like a whole bunch of people who might have experience, and when I say this, I'm not saying everybody, but yeah, you're going to find some, and lay out the tools and just go, there's a cool 1,000 for whoever can get into this lock. Go. And I bet you'd see some real effort put into it, as opposed to this guy who's really, like, if he breaks open the lock, he's probably getting fired, not rewarded. So this is not a great test to my mind. But all right, I'm interjecting too much. Let's go.
So you can't place me. We're gonna quickly bypass these. There's just
He's like, I can't reach the, I can't reach, this part. I'm just like, well, can the bolt cutters cut through this part? Because that's really accessible. He doesn't even try that on the video, but I'm like, that's my question. Again, I'm not going to try it because weak noodle arms. This is not how I'd try to get into a lock.
there's no way you're.
This now is the part that really causes this whole shitstorm. And I think this part is really going to be a major influence on any eventual trial. So GQ Videos says, let's introduce it to the McNally official poke. So Trevor McNally, they're tagging Trevor McNally there. And what does Proven Locks say? They say, lol, those guys like the cheap locks, lol, because they are easy and fast. So it's very much a call out. It's very much saying, listen, Trevor McNally is, basically they're saying he's a hack, that he's not actually bypassing any locks of any substance, and that their lock would defeat him. So here we go. You can see that's made from a pop can, and he twists, and he futzes with it a bit, and then boom. Now, Proven Industries claims that video must be edited, that there must be multiple takes kind of spliced together. And they do that because they say the shim changes shape. Well, yeah, it's a pop can shim and you're yanking on things. It's going to deform. I didn't see any cuts there. I actually went through that like frame by frame. I couldn't find a single cut, like anything that looked like an obvious jump or anything like that. If it is cut together, and I don't think it is, but if it is, then they are like video editing wizards. So, I already went through the complaint, but Proven Industries turns around and they are upset. They're angry. And so what they do is they bring an emergency motion. And now, I already went through the complaint, as I said, and I thought that their complaint is hot garbage. Watching that video, you can see they use a portion of the Proven Industries video, and it's clearly for commentary or criticism. They're clearly mocking it. Now, Proven Industries says, well, it can't be criticism because he doesn't say anything. You don't have to say anything to mock something, right? Just as an example of a way you can communicate emotion without or feelings about something without verbal anything. For instance, you could make a skeptical expression. Maybe not my best skeptical expression. I'm not an actor or anything. Or the classic example of nonverbal communication. Not saying anything, but it sends a signal, right? You could pick a fight with that if you wanted. So don't try it in traffic. So let's jump in and have a brief look. We're going to rush through this because there's multiple documents I want to cover, and I want to try to keep it a little short. So they say plaintiff's emergency motion for preliminary injunction. What they're asking for is, well, they want to make Trevor McNally take down all of his videos and stop putting out additional videos mocking them. What additional videos? Well, they accuse him in this lawsuit of editing. So he shows one where, of like preparing or whatever. So he shows one where he opens a lock right out of the Amazon box. He does one where he opens several locks in succession. All right. Plaintiff, Proven Industries, pursuant to the rules, moves for a preliminary injunction enjoining defendant Trevor McNally from infringing Proven's copyrighted video and publishing content that falsely implies Proven's lock products are insecure, trivially bypassed without skill or preparation, and that Proven knowingly misleads customers about the product's security. I don't know that he actually said anything about knowingly misleads. He just sort of implies that you're making a bad product. And quite frankly, my opinion is that they are making a bad product. I don't know about knowingly, but certainly at this point, instead of hiring the lawyers, they should have been hiring engineers. Like, hire somebody to fix the problem instead of to sue the critic. That's probably a better way to go. So, and I mean, it would be really easy to fix the problem. You just square this off so that it's, flat, or you put in a secondary pin that blocks it unless the key's in there turned. It might make it a little less convenient to lock, but it makes it vastly more secure. So, request for emergency relief under Local Rule 3.01e. Defendant continues to maliciously publish social media videos that falsely imply Proven's locks are easy to unlock without a key and without preparation, expertise, or training, even after Proven filed its verified complaint based on the same assertions. Yeah, that's kind of how, freedom of expression works. All of defendant's videos employ the common theme of falsely implying Proven's locks are easy to unlock without a key and without expertise or training. In my experience and my opinion, they were not super difficult without a key and without experience or training. In fact, all I needed, I did open the lock first to have a look at it. So, I mean, okay, but I don't think that was actually a necessary step. But all I really used was Trevor McNally's video and saw what his shim shape was vaguely like, and then tried to replicate that based on the video. So, and they say this video comes one day after Proven's counsel advised defendant's counsel about an email from one of Proven's employees expressing concern for the employee's own safety and job security because of the hundreds of violent, sexual, and threatening messages Proven received because of videos defendant published on May 23rd, 2025 and May 25th, 2025. So here's the thing about bad press. The world is full of a-holes. Now, most people are reasonable and decent people who just, they see something like this and they go, well, I'm just not going to buy that product. But 2% of the people or 1% of the people who see something might be, or even a fraction of a percent, might be crazy enough to send some threatening message because they're just not really all there. So any criticism online that gets traction is going to result in this. I have received death threats. I don't know anybody who hasn't received some sort of hostile message, and I mean, I'm fairly well liked overall. If this was the standard that you can't put out stories because it might result in somebody on the internet being, hostile, then there couldn't be any news coverage unless it was positive. There just couldn't be anything out there. And in fact, even positive coverage can result in this. So, yeah, carrying on. They say the imminent damage justifying emergency relief is the ongoing and escalating reputational and commercial harm to plaintiff caused by defendant's retaliatory conduct. Defendant will not stop until he destroys Proven's reputation, which is actually interesting because I think that this could be a point of agreement. This could be a point in common because it seems like Proven will not stop until it destroys Proven's reputation. Filing this lawsuit, going after Mr. McNally, is not what you want to do if you want to repair your reputation. What you should do if you want to repair your reputation is fix the lock. There are other companies out there that make lock products, and those lock products have been bypassed by people like Lockpicking Lawyer and so forth. And you can absolutely turn that into a success if you just fix the problem and, address it. The lock community loves that, and that is the main reason why you get a lot of the lock picking, lock bypassing, videos out there. Is they're like, we don't want people buying bad products. We want the world to know which products are good, because as a lock picking idiot, I might have looked at this and gone, oh yeah, this is amazing, but only discovered later when my trailer was gone that it wasn't so great. This is actually really important information for consumers. Okay, so what is their main issue here? They say that he's using excerpts from their copyrighted promotional video without authorization, combined with a misleading lockpicking demonstration. How do they say it's misleading? They say the demonstration omits critical facts. McNally had already disassembled the lock or used the key to open the lock to inspect its internal mechanism. Well, here's the thing. If the only way your lock is secure is if nobody on Earth has ever opened one before in order to see this problem, then it's not a secure lock. If it relies on the top secret information of nobody could ever see this piece, then that's not secure, right? It's about as secure as having your password to your computer taped on a Post-it note under your desk. Like, they left out that getting into this computer required looking under the desk and seeing a Post-it note is not a great, yeah. All right. And custom fabricated a shim specifically for that model. I mean, okay, they cut a shim out of a pop can. It's not super specific or anything. McNally's video falsely portrays the bypass as immediate, effortless, and replicable by an average person using a scrap of aluminum can. As noted, I couldn't replicate it the way he did because he got a nice clean open that actually left the lock intact. I got it where the piece of aluminum can was stuck in this and left it, sliding freely. But it didn't take me long, and I'm an average person. In fact, at lockpicking, I'm probably a sub-average person. So, yeah. After pre-suit notice and multiple DMCA takedown requests, Part 1 was removed from all platforms except TikTok. Rather than de-escalate, I'm sorry, you're not de-escalating, you're escalating. McNally retaliated by publishing 3 additional videos, each building upon the original defamatory implication. These follow-ups target the same and additional proven products while again omitting context and staging demonstrations under unrealistic conditions, e.g. shimming a lock while not affixed to a trailer coupling. All right, so yeah. They're upset that he keeps putting out videos every time, like when Proven Industries says, oh, he can't open it because of, or his video is fake because of this. He addresses and responds to those videos, which is part of the sort of dialogue and discussion there. All right, we're not going to cover the rest of this request other than to look at sort of what they demand, which is they're asking for an injunction preventing him from reproducing, displaying, distributing, or otherwise using any portion of their copyrighted audiovisual work titled "You Guys Keep Saying You Can Easily Break Off Our Latch Pin Lock," including any excerpt or derivative thereof in any medium or format, publishing, reposting, or distributing any video, post, or content that falsely implies plaintiff's lock product can be trivially bypassed without tools, expertise, or preparation, publishing, reposting, or distributing any video or post that combines visual elements of the proven video or plaintiff's product branding with misleading depictions, omissions, or stage demonstrations intended to imply product failure. Encouraging, promoting, or directing others to post false reviews, submit misleading inquiries, or engage in coordinated online activity based on the McNally video or its false implications. Failing to remove any existing videos. An injunction against failing? Okay. Social media content or online comment that incorporates the proven video or promotes the false implication that plaintiff's product is ineffective or deceptively marketed. Failing to preserve all drafts, communications, posting data, affiliate marketing records, and monetization metrics related to the creation, dissemination, and performance of the McNally video, and awarding such further relief as the court deems just and proper. I'm just going to take a second here to address Proven. You guys might be inclined to issue a DMCA request against this or a takedown or anything. If you do, you know it's false because you know that my use here is fair use / fair dealing. And, you know, I credit you in the thing. I note that some of that content is your original content, but also it is very clear that this video in its entirety is now a legally relevant issue. I comment over it. It is not a substitute for your content in any way. So just a little cautionary note. The DMCA takedowns are, you know, under penalty of perjury. Maybe don't file a bad faith one. Just a thought. It's also, if you do, I'm just going to turn around and make more content about that. Don't do it. It's a bad idea. I can tell you, Streisand affecting yourself even worse is a really dumb move. Okay, so that little warning in there. And yeah. So McNally files a response. Now, this response is interesting because this is a response to the emergency motion, and it's not actually their full statement of defense. So we're going to get more details about their defense later. But here we go. And again, we're just going to cover this really, really quickly. This is going to be a real brief overview. So Trevor McNally is a social media content creator who, among other things, posts videos exposing flaws in common locks to consumers. Proven Industries manufactures locks, including a $130 Model 651 latch pin lock, the Proven lock. After being publicly challenged by Proven, McNally published a video in which he bypassed the Proven lock with an aluminum can in a matter of seconds. Rather than accept the fact that its lock could be easily bypassed and address the flaws in its product, Proven attacked McNally and filed this lawsuit. And they have this little note here saying, we haven't filed any response, but we are maintaining a defense against jurisdiction, i.e. that this is filed in the wrong place. They're saying we're not waiving jurisdiction issues, we just have to file a response because you're doing an emergency motion here. In this case in motion, Proven attempts to use this court to silence McNally by forcing him to remove social media content and prohibit him from posting about Proven. Proven's motion seeks an unconstitutional prior restraint and should be denied outright. What is prior restraint? Well, let's say there's somebody out there who really hates me. And I think that they're going to say defamatory things about me, so I want to get a court order preventing them from saying the things before they say the things. And the court is almost certainly going to tell me to go to hell, because that would be prior restraint. I want to prevent them from saying something before they've said it. And the courts have said that the standards for prior restraint are really, really, really high. So, yeah. Aside from the First Amendment concerns, Proven's motions should be denied because it fails to establish the elements necessary for a preliminary injunction. So, a little bit of background. McNally is an honorably discharged, medically retired United States Marine Staff Sergeant. Now, this is purely in here for sympathy value, but I'd put it in 100%. McNally operates the world's most viewed lock niche social media accounts on Instagram, Facebook, YouTube, TikTok, and Threads, where he posts videos showing flaws in common locks. On social media, McNally makes cutaway locks that show the internal components and operation of different locking mechanisms. Most viewed is super impressive, because I can tell you, I am not most viewed in anything other than maybe like legal content published by a guy with long gray hair. I also joke that in the firearms niche, I have the second best firearms channel run by a guy named Ian, and that's probably not even true. So, Proven manufactures various locks, including the Proven lock. All right, skipping ahead a little bit, they note, after an Instagram user commented on the Proven video suggesting that McNally could open the Proven lock, Proven responded stating, "Lol, those guys like the cheap locks, lol, because they are easy and fast." McNally understood Proven's comment as a challenge, and in response posted a video of himself opening the Proven lock in a matter of seconds with an aluminum can in one continuous take. And this is part of internet culture. Like, if you call someone out, the likely response is that they're going to, call back. And especially something like this. Like, if I posted a video saying, Trevor McNally could never break into my car, I would not be super surprised to find a video of, like, McNally driving my car away. And I'm sure he'd put it back when he was done, but, it'd be funny. So, McNally did not alter the Proven lock and required minimal preparation to bypass the lock. The shim McNally used was not a unique design and did not require precise dimensions. So this is attacking their notion of, like, it has to be this custom-made shim. He's like, no, you can just eyeball it. Moreover, the Proven lock uses a spring latch locking mechanism that has been one of the most common features in locks for over 150 years, and is not super secure. The same day that McNally posted the McNally video, Proven sent McNally a direct message stating, "Just wanted to say thanks and be prepared." One day later, Proven sent a text message to McNally's wife and called her cell phone, purportedly trying to contact McNally. That's a party foul. If you're pissed at me, talk to me. Don't talk to my wife. Full stop. Numerous viewers commented on the response video criticizing Proven. Proven engaged with many of these comments, and during those interactions asserted things were going to get really personal for McNally. Proven published multiple comments claiming and/or insinuating that McNally was misleading viewers with the McNally video. That doesn't look good, right? So, and then he goes on to say that he publishes additional videos. In another video, in one continuous shot, he retrieves a new Proven lock in its original sealed packaging from an Amazon locker and shows the entire process of creating a shim and bypassing the lock. On May 25th, he posts another video in which he retrieves another Proven lock in its original packaging from an Amazon locker and demonstrates another method of shimming the lock, again in one continuous shot. And two more videos in which he shims other Proven locks to show that the shim design is not specific to the Proven lock. All right, so all of this is is not so great for them. So, argument. The first argument is the unconstitutional prior restraint. We already sort of briefly covered that, and it notes that any prior restraint bears a heavy presumption against constitutional validity. Based on these significant constitutional concerns, the judiciary routinely refuses to enjoin speech before the final adjudication of the defendant's liability. Because let's imagine you sue somebody for defamation, right? And then you get an injunction that prevents that person from talking about you. And this is during some, like, active court battle or, active issue. Well, 2 years later, the court case resolves and the court says this was not defamatory. This was free speech. But you've been prevented from talking for those 2 years. You're basically prevented from ever really having any meaningful comment on the issues. And I'm actually going to steal those citations for another case I've got going on. So thank you. I'm just stealing that. Yeah. All right. So they argue Proven's motion should be denied because it seeks relief beyond that framed by the complaint, i.e. they're asking for other stuff that they wouldn't get even if they won. Skipping ahead a little, Proven cannot demonstrate it's entitled to a preliminary injunction. What does it mean to be entitled to a preliminary injunction? Well, they're going to explain that. They say that they have to have a substantial likelihood of success on the merits, which I don't think Proven can show, because I look at their case and I go, that is freaking stupid. Irreparable injury will be suffered unless the injunction issues. Let's talk about what irreparable injury means. Irreparable injury is something like, let's say I'm going to lose an arm unless the injunction goes through, right? The court can't fix that. They can't put my arm back on. Let's say I am going to, but what isn't an irreparable injury? Money. Money is never an irreparable injury because the court is great at giving out money. That's what they do. It's how they work. So if you're saying you're going to lose a whole pile of money, the court's like, well, we got a solution for that. We just award you a whole pile of money if you win, and then you're square. So irreparable injury has to be something that cannot be fixed by money. And keep in mind, the court has a very broad definition of what can be fixed by money. 3, the threatened injury to the movement outweighs whatever damage the proposed injunction may cause the opposing party, so a balancing of interests. And 4, if issued, the injunction would not be adverse to the public interest. Here, the public interest would be harmed, because I think the public actually has a substantial interest in hearing if a law is bad and in free speech issues. So, yeah. They're breaking this down. Proven cannot show a likelihood of success on the merits of its claims. I'm going to skip mostly past this, but I will note that in watching that video, you can tell that it's clear that video is there for criticism, comment. The part that they object to most, the juice box with the legs kicking, that's clearly intended as criticism, right? He's clearly making fun of them. He's clearly going, yeah, you think, brah? Right? The purpose and character of the use was transformative. Absolutely, it's transformative because the purpose isn't, the original purpose is to market Proven Industries works. The new purpose is to criticize Proven Industries works. They're absolutely a new meaning to it, right? So skipping on, the nature of the work was minimally creative and previously published, i.e. it's an advertising work that they'd already published. The portion of the work used was minimal and integral to the criticism. They use about 16 seconds out of a 90-second video, and it's kind of critical to show what they're showing there. The use had no effect on the market because there is no viable market for Proven's video. I think this is an excellent argument because ultimately Proven's video is an advertisement. And you know how much money I will pay you to watch an advertisement? $0, right? Nobody is going to license an advertisement from Proven Industries, right? The only person it's got value to, as they say, is the Proven video is a promotional video that has no value to anyone other than Proven. They're unlikely to succeed on their defamation claim. I think that is, yeah. So basically they go through the rest of the claims and they say they're unlikely to succeed. Okay. And then Proven, we're going to cover this really briefly. They have a reply to the defendant's opposition. So they say, we don't seek a prior restraint. We seek restraint on the things they've already made. Which is actually not correct because they asked them not to publish any further videos. So, yeah. Now, this is also funny. They say defamation by implication is premised not on direct statements, but on false suggestions, impressions, and implications arising from otherwise truthful statements, which is a hell of an admission to make in this case, right? Because, oh, it's otherwise truthful, is it? Thus, even if the McNally video is a true statement, defendant's omission of critical facts, such as the need for operational knowledge of Proven's locks, who cares? Like, this is not relevant. Knowledge of shim fabrication and placement, or repeated trial and error, none of this matters, honestly. Creates the false impression that plaintiff's lock can be easily opened when in use and without a key. If this goes to trial, I can almost guarantee that they're going to be, like, showing the jury how easy these things are to open, and that's going to be real bad for Proven Industries. This lawsuit is such I think this lawsuit is meritless. I I honestly think that instead of spending the money on the lawyers, they should really have hired, somebody to engineer the problems out. You know what? I'll save what I think that they should do to the end. Okay. Plaintiff's motion for injunction seeks relief consistent with. So basically, they're arguing that they got everything out of it. They finally get to a fair use analysis, and their fair use analysis is weak. They say defendants' argument that the McNally video is transformative fails. They cite Hasinzada, I hope I'm getting that right, to argue that the McNally video constitutes critique or commentary. Unlike in that case, where the court found fair use because the defendants inserted verbal commentary that expressly critiqued the original video, here McNally makes no verbal commentary on the proven video. But he clearly makes commentary, right? There's clear commentary there. Even if defendants' conduct could be viewed as commentary, it can and it is. It targets the product shown, not the content, message, or expressive elements of the proven video. It actually does target the message. The message of the proven video is our locks are secure. The message of McNally's video is no, they ain't. The proven video conveys a message about the lock's durability. Defendant does not comment on or critique that message. Instead, McNally's silent shimming demonstration is I like how they acknowledge that it's silent, is unrelated to the substance of the proven video and offers no critique or commentary on it. They're like, we're saying it's hard to get into with a sledgehammer. We never said it was hard to get into with a pop can. Well, I'm pretty sure the implication of showing that it's difficult to get into with all of these things really shows that it's that. And further, I think that part of the message of the video is included in your commentary on the video in your Instagram comments. So, yeah, they're just, they're saying McNally's use of the proven video is not transformative commentary, it is illustration. Okay. I don't think that's going to fly. Nature of the copyrighted work. It's a creative, professionally produced marketing work that includes original audio, video, content, scripting, and branding. Such creative works are entitled to strong copyright protection. Amount and substantiality. They say 16 seconds from a 90-second video. This segment includes the most recognizable and persuasive portion of the proven video, its introduction and product messaging. Courts have held that copying the heart of a work, even if quantitatively small, militates against fair use. What is the heart of a work? Well, let's say I do a biography of a famous person, right? George Washington. And I am the first person ever to discover some unusual fact about George Washington. Maybe I've found conclusive proof that he had like 3 nipples or something. And that's in my biography, right? And that's just one chapter of a 60-something chapter biography of George Washington, is this new 3rd nipple bit. That might be the heart of the work, because that might be the reason why people want to buy my biography instead of other people, is to figure out, like, wait, what are you saying about him? Like, what's this 3rd nipple business, right? That might be the heart of the work. If, a particular song might be generally boring other than one particularly creative, like, drop, that might be the heart of the work. So this is the issue. I don't know that they can say that this is the most persuasive portion, but I guess you make the argument. Effect on the market. Fourth, the effect on the market weighs heavily against fair use. Defendants' unauthorized use distorted the proven video's messaging and diminished its value as a commercial asset, undermining its utility in future campaigns or licensing. This is actually an argument for McNally, because they're basically saying he criticized our video so effectively that we couldn't use it, right? Imagine I do a video and, and I talk about, George Washington's 3rd nipple, and somebody mocks the hell out of it and also, disproves it. They go through and they address every argument I make in favor of this, and their criticisms are so damaging and so devastating that I end up having to take my video down because I'm just so thoroughly discredited by their video. That's what free speech is about, folks. That's why the First Amendment exists. So, yeah. Um, Defendant conflates the requirements for defamation by implication with that of defamation. So they're saying defamation by implication arises not from what is explicitly stated, but from what is implied through omissions, context, or the juxtaposition of facts. And they cite a case holding that the unauthorized use of plaintiff's image on adult film packaging, falsely implying her association with pornography, constituted defamation by implication. You can see that the massive difference there, right? If I am selling a spicy video and I put a particular celebrity's face on the package, then that implies that she's in the video, right? It implies that, like, you can watch this video and you're going to see her doing spicy business. Which, you know, assuming that that's not true, that's a big problem. But that's not what's happening here, right? They're saying it's slightly harder to open it. You'd had to, I mean, if Proven Industries' argument works here, then literally no criticism is possible, because any criticism is by necessity going to be, you know, you can't talk about every single detail. So they say defendant's videos falsely suggest Proven's locks offer little to no security because they can be easily opened without a key. In reality, bypassing the lock requires prior knowledge of internal components, which you can get from watching the video or just looking at one, and the use of custom tools. The custom tools being, I cut some pop can. Like, that's not impressive. It's not like some, you know, specific lockpick or something. It's just a piece of pop can with a circle, semicircle cut out of a strip of it. And that Proven manufactures insecure lock products. I mean, I have no problem showing you guys this because I'm never putting it on a hitch. All right. So you might be wondering, well, this is really bad for McNally. What's he going to do? Well, I already said that this starts off with Proven Industries taking another L. And how does that happen? Well, let's just go to the minute entry from the judge here. This matter is before the court on plaintiff's motion for preliminary injunction. Plaintiff's witness sworn and testified on direct examination, cross-examination, redirect. Plaintiff's 6 videos admitted, defense exhibits admitted, plaintiff's exhibit admitted. Plaintiff's motion for preliminary injunction is denied. So, Proven Industries has taken their first L in this case, and I expect it'll be the first of many. Now, I said I'd talk a little bit about what I thought Proven Industries could do. What are their options? How could they handle this better? I mean, if I am Proven Industries, I am reaching out right now I'm probably reaching out and going, hey, now, I mean, this is, if I'm Proven Industries counsel, here's what I'd be suggesting to them. I'd be suggesting, listen, you know, if they fired their previous guy and hired me, this is a hypothetical. I'm not saying they should do that, and certainly I would not be eligible to be their lawyer, not least of which because I'm commenting on their case publicly. But in this hypothetical, the first thing I would say is, listen, A, I don't think your case has merit, but B, you have a really big problem with respect to this case is not going to get you what you want. The Streisand effect is a real thing, and you are damaging your reputation by fighting your critics instead of acknowledging your issues and rolling with it. And what I would probably do is I would probably reach out to McNally and say, hey, I have an offer to settle, and here's how it goes. Our offer to settle is we're going to drop this case, but we also want to hire you and Covert Instruments to help us fix this. And we want to also hire you to do a video with us, and we're going to pay you a pile of money to do it because we screwed up, to make a video with us saying, we learned, we're fixing this, and that'll be awesome, right? Wouldn't that be so much more effective and so much cheaper than this litigation and so much, you know, this is the difference between a lawyer who knows the law and a lawyer who knows pragmatism. And one thing I'm sort of noticing as a sort of running theme is that you've got lawyers who just do not understand the social media landscape. If I was a profit-driven guy, which I'm not, my goal is to have this channel fund my life so I can do legal work for free. But if I was a profit-driven guy, I think there's a market for somebody who actually understands the social media landscape and can litigate within that. And sadly, I don't know who that person is. I know that there's some people who pretend at that, but they don't do a good job. At least not from what I've seen. They seem to actively do stuff like this, where they blow up. Like, this is to me exactly how I wouldn't want to play things. Now, I said that I also was not super impressed with Proven Industries for other reasons. And one of the reasons is something I'm just going to pull up on the screen right now. And this is an additional unidentified by McNally insecurity, at least in my opinion. And let's talk about this. It says, I lost one of my keys. Can I order new keys? Whether you need just a new set of keys, or if you want new locks keyed to match your existing key, we can do that for you. Great. That's an excellent service to offer. This can only be done by contacting our customer service team at support@provenlocks.com. We will need photos of your existing key showing the code. The photos reduce the likelihood of errors when this code is provided to customer service and then passed to our key cutter. Photos also act as proof of ownership. This must be an original, as duplicates do not have the code stamped onto them. We do not keep key codes on file for security purposes. That's a good thing, that they don't keep key codes on file for security purposes. They say it is recommended that you keep a photo of your key code in a safe place or order a second set of keys to keep in a safe place. If you do not have the ability to get the code from your key, we cannot cut new keys to match. Now, I'm just going to note, the things I'm going to do on this thing are because I never plan to use this lock for anything significant. If you want to use a lock, don't ever do what I'm about to do, which is I'm about to show you the keys. So you can see the key, and you can see it's got that lovely little code 0287. Now, what that key code is it helps them get the bidding of this key. Again, never take pictures of your keys and share them publicly, because it'll allow people to potentially, bad actors to cut keys. I'm doing this because this is only for use as a prop in videos. I will not be using this for any security purposes. But the thing I want to criticize, the decision I want to criticize here is, and I'm just using the key to open it. It's actually a bit of a pain in the butt key. But actually, no, I'll just close it up because you can see it just fine when it's closed. What do you see on the closed lock? 0287. So you can get the key code without having the keys. So they say it's a security feature that you have to send them a picture of the keys, because then... Now, I'm betting, I haven't actually done it, but I'm betting I could talk them into giving me the key, cutting new keys. And again, this is pure hypothetical, right? I haven't tried it, so maybe they'd tell me to go fuck myself. But with that, but more than that, if you found a picture of a key online, like say on some video somewhere, and I checked, before I did this, there's already lots of pictures of these keys out there. It wouldn't be hard to Photoshop this to show different numbers here. And I wonder if they check each photo that goes in for that. And you can get the code from this. So there's a non-trivial possibility that, and you say, well, this would never happen. Yeah, it would, actually. Criminals have been known to do this, where you go and you see the code on something. I like the idea of you need to send in the picture of your keys. That's great. Don't put it on the lock where it's publicly facing, where any idiot can see this. Put it somewhere. And I wonder why they did that. Like, if it's impossible for me to talk them into getting sending me new keys without showing them a picture of the keys, why have the code there, right? Because that just makes no sense to me. So, yeah, I look at that and I see it as a sort of threat vector of somebody who is going to engage in some social engineering, might be able to convince Proven Industries to send you a key for a lock that you don't own. Yeah, I don't know. It's concerning. So, um I I really wish that the response to things like this wasn't lawsuits. And I also know that in making this video, I have some concern that I might get a takedown or I might get a legal threat because there's a certain range of sort of safe behavior that you get when you're dealing with reasonable people. But I'm not sure Proven Industries are like, I don't know, but so I guess we'll see. I mean, if they take this video down, the first thing I'm doing is I'm doing a new video where I will probably comment on, hey, this portion used to be where I showed the video, but we have to cut it because Proven Industries. So we'll see. Proven Industries, prove me wrong. As long as this video is up, you're at least showing some reasonability. All right, so thank you guys for watching. I hope you found this to be interesting or educational. We managed to get through 3 court documents in brief in under an hour, which is way better than my usual because I love to go through court documents in full detail. If people want, I will go through those things in full detail, but I think we've covered the critical elements. So I want to thank you guys for watching. I hope you found it to be interesting or educational and an important update on what's going on. I would love to get the details as to what happened in that hearing, but, you know, not televised, not available, because I would love to hear what the court's findings were on the likelihood of success, particularly. So, I also want to thank my Patreon supporters. I've got a link to that in the description below. At the $50 level, Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Coalition for Firearms Rights, and the Canadian Shooting Sports Association, PJ's Forever, Angela Skelton, Cielo, Purple Dragonair, and Shay B. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, and Marvin CZ. Thank you as well to my $10 supporters who will be in the crawl immediately watching. Thank you for watching. Hope this is armed you with knowledge. See you next time.